Okay, so I want you to imagine the scene for a second. Put yourself there. It's chaotic. You've got flashing lights shouting, people everywhere holding signs. There's probably a megaphone blaring right next to your ear. It's a protest, and it's specifically about immigration and customs enforcement, ICE.
Emotions are already at a 10.
Oh, they're boiling over. It feels urgent.
It's a powder keg. That's really the only way you can describe it.
Exactly. And in all that noise, all that adrenaline, you see someone step forward. Maybe they just want a better angle for a video they can post.
Right.
Or maybe they feel this, moral obligation to stand their ground in front of a transport van to stop it. It feels like a moment of true conviction.
But in that one split second, the whole atmosphere just shifts.
And not just emotionally, but legally.
That is the moment. That's what we're obsessed with today. That specific microsecond where a situation flips from a constitutionally protected political statement into a federal felony.
And we're not talking about, a night in jail and a small fine here.
No, not at all.
We're talking about federal charges that can carry decades in prison. It's actually kind of terrifying how fast that switch can flip.
It really is. You go from citizen to felon in like the blink of an eye. And the consequences are often so disproportionate to what the person thinks they're actually doing in that moment.
Today, we are doing a deep dive into this very specific, really intense piece of analysis. It's titled Interfering with ICE at Protests, Federal Charges and Penalties.
It was written by Herfel, published just recently, January 29, 2026.
And this piece is it's fascinating because it's basically a roadmap of the federal criminal code.
It is, and it strips away all the politics. It doesn't care about your stance on immigration or, borders or policy. It just looks strictly at the statutes. These are the workhorse laws that federal prosecutors pull out when a protest turns physical.
And that's our mission today. We're going to try and map out what the source calls the invisible fence. We want to really understand where free speech ends.
And where criminal interference begins, according to the U.S. Code.
So we're just looking at the mechanics.
Exactly. What the law says, how the Department of Justice interprets it, and what the consequences are. It's a totally neutral look at a very volatile reality.
Okay, so let's unpack this.
Yeah.
The source starts by drawing this really hard line in the sand. On one side, you've got what they call the safety zone. This is the First Amendment stuff we all know and, expect at a protest.
Correct. The safety zone is everything you'd think it is. Filming, chanting, holding signs, criticizing the agency, organizing the event.
So you can be loud?
You can be loud, you can be angry, you can be present. As long as you're engaged in speech or assembly, you are, generally speaking, on solid legal ground. That's your constitutional right.
But then you cross the line. The source calls this the trigger. And it's not vague about what pulls it.
No, the trigger is conduct. That is the key word. Your criminal exposure begins the second you move from speech to force, intimidation, or physical obstruction.
And once that line is crossed, the article points to one specific statute that seems to do most of the heavy lifting for the government. They call it the workhorse statute.
That would be 18 U.S.C. Section 111. If you remember nothing else from today, just remember Section 111. It's the primary federal law for assaulting, resisting, or impeding federal officers.
And just to be super clear, because I think people get confused about jurisdiction. They think, oh, this is a local police thing. This applies to ICE agents specifically.
It absolutely does. Under another statute, 18 U.S.C. Section 1114, ICE personnel are designated as protected federal employees.
Okay.
So if you interfere with an ICE agent who's performing their official duties, Section 111 applies directly. You're in federal territory now.
It means federal court, federal prison.
And federal sentencing guidelines. It's a whole different world.
So Section 111 is the big one. But this is where the source gets really interesting. And honestly, this part made me sit up a little straighter. There's a pivot word in the legal text. One single word that changes the entire game.
The word is forcibly. The statute makes it a crime to forcibly assault, resist, or impede. Now, be honest. When you hear forcibly, what's the image that comes to your mind?
I'm picturing a brawl, a tackle, a punch being thrown, something with real impact, something that leaves a bruise.
Right. Most people do. That's the common sense understanding of force. But the legal definition is much, much broader, and the source makes a point to highlight the DOJ's guidance on this. Force doesn't have to mean impact. It can be established just by a threat.
A threat counts as force, even if you don't touch anyone.
If that threat causes a reasonable fear of harm, yes. Especially if you pair it with some kind of aggressive movement.
Can you give me an example of what that looks like? Because that sounds really subjective.
Sure. So imagine an officer is walking a detainee to a van. You don't touch them, but you step right in their path aggressively. You close the distance fast. Maybe you raise a fist or you lunge, and you shout something that sounds violent. Even if you stop an inch away, even if you never lay a finger on them, you've created an immediate fear of harm.
So you forcibly impeded them just by how you approached.
Precisely.
Yeah.
You've triggered the statute. The law says you use the threat of force to stop them from doing their job.
That is a huge, huge distinction. You don't have to land a punch to be charged with forcibly impeding an officer.
Not at all.
Now, the source breaks this down into tiers of penalties. And this is where the math starts to get really scary.
It's a tiered system, and it's all based on the severity of that conduct. So at the very bottom, you have simple assault.
And that's a misdemeanor.
It is punishable by up to 1 year in prison.
1 year is already a long time for a protest that went wrong, but okay, that's the basement level. What happens when you go up a tier?
This is the critical jump. It happens with physical contact. This is where the source is very specific. If there is any physical contact, shoving an officer, grabbing their arm, yanking on a van door, it immediately becomes a felony.
And the prison time.
The exposure jumps from 1 year up to 8 years.
Wait, hold on. 8 years. Just for physical contact. Even if nobody actually gets hurt.
That's the law. The statute focuses on the act of contact and the intent to impede, not necessarily on the medical result. You don't have to break someone's nose to face 8 years. You just have to make contact in a way that interferes with their duty.
The source used a really specific example here that I thought was so illustrative, trying to uncuff a detainee.
Right, and this is a common impulse you see in these chaotic moments. Someone sees a detainee being led away, maybe it's a family member or someone from their community, and they reach in and try to, get at the handcuffs to free them.
It feels like a rescue attempt, like a humanitarian impulse.
To the person doing it, absolutely. But to a prosecutor, it's a felony. That act involves touching the officer, or at least the equipment under their control. That alone catapults the charge right into felony territory with that 8-year maximum.
That's a massive escalation for a split-second decision, and then I'm assuming there's a tier even above that.
Yes. If there's a deadly or dangerous weapon involved, or if bodily injury actually does occur, the maximum sentence shoots up to 20 years.
So we go from 1 year to 8 years to 20 years.
All based on the level of contact and the consequences. And remember, these aren't just some hypothetical maximums that never get used. These are the guidelines prosecutors start with when they're building an indictment. They define the whole playing field.
I want to help people listening visualize this, because impeding can sound vague until you see it happen. The source lists some specific scenarios, these fact patterns, that prosecutors look for. What does this actually look like on the street?
One of the most common ones is surrounding a vehicle. Imagine a van trying to leave a facility. If a crowd mobs that van so it physically cannot move.
Okay.
Or if people start rocking it or grabbing the door handles.
And grabbing the door handles, that goes right back to the physical contact rule we just talked about.
It does. If you grab the handle to stop the door from closing, or you're trying to pull it open, you are physically contacting federal property to impede an officer. That's a potential 8-year exposure right there.
Wow. Okay, what else?
Another one is the human barrier. This isn't just standing on a sidewalk. This is linking arms and forming a physical chain at a gate or across a driveway to stop a transport vehicle.
So it's a difference between I am protesting here and I am physically stopping this operation.
You're using your body as a lock, and the law treats it that way. Then there's rushing. This is running toward an arrest team. The legal logic here is pretty interesting. By rushing them, you're forcing the officers to divert their attention from their duty like securing a detainee to their own safety and crowd control.
So even if you don't get close enough to touch them, the fact that you forced them to turn around and deal with you means you've impeded the operation.
You've successfully disrupted a federal officer's duty. That's the charge. You've forced a reaction that prioritized your threat over their main assignment.
And the source mentioned throwing objects, right? Even small things.
Yes. Water bottles, trash, whatever's at hand. The source notes that even small items count if they cause officers to flinch or retreat or take cover. Again, you forced a reaction that stops them from doing their job.
It really paints a picture of a very, very sensitive trigger. It feels like in the heat of the moment, doing something that seems minor nigh, tossing a water bottle, grabbing a handle, carries this massive legal weight.
It does, and the source actually calls this the non-touching felony, We touched on it, but it's worth repeating. You can get that felony charge without laying a finger on anyone if your threats and your aggressive movements create that reasonable fear.
So that's the individual level. But these protests are rarely one person. It's a crowd. It's a movement. And the source talks about how the nature of the crowd itself can add another layer of charges. They call it civil disorder.
This is 18 U.S.C. section 231A3, and prosecutors love using this as an enhancer charge.
An enhance?
Yeah. If the whole setting is volatile, chaotic, or described as a civil disorder, and you obstruct law enforcement during that time, they just slap this charge on top of everything else.
Like a chaos multiplier.
Essentially. The source references a real-world example from St. Paul, Minnesota, where a woman was charged under the statute because the obstruction happened during a period of civil unrest. It signals to the court that this wasn't just a peaceful protest, it was a disorder event. It paints the defendant as a participant in a riot, not just the lone actor.
Okay, now this is where it gets really interesting to me. The difference between a spontaneous protest and a conspiracy. The word conspiracy sounds like something out of a spy movie.
Or organized crime, right?
Yeah, but the source says it applies here.
Oh, it absolutely does. 18 U.S.C. section 371 and section 372. This is what the source calls the conspiracy multiplier.
So how does a protest become a conspiracy? Is it just about how many people show up?
No, it's all about planning. That's the bright line. If you just show up to a protest and you start yelling, that's spontaneous. But if prosecutors find evidence that you planned in advance to obstruct, that's conspiracy.
What kind of evidence are they looking for?
Group chats are the gold standard.
Group chats, like on WhatsApp or Signal.
The message is right there on your phone. If they find texts that say, we're going to meet at location X specifically to stop the transport van, or, hey everyone, bring zip ties to block the gate, that proves an agreement to commit an offense.
So the text message thread where you're organizing the carpool could be the evidence that turns a misdemeanor into a conspiracy charge.
If the intent in those texts is to physically impede officers, yes. Conspiracy to impede an officer under Section 372 carries up to 6 years. And here's the kicker.
Uh-oh.
Conspiracy charges don't require you to actually succeed in stopping the van.
They don't.
No. The crime is the agreement itself, plus an overt act to carry it out. Driving to the location is the overt act. So even if the van never shows up or you get arrested before you can even get near it, you've committed conspiracy because you planned it and took a step toward doing it.
That is a crucial distinction. The crime is the plan.
Correct. It turns group activity into felony time.
We've talked about physical confrontation and planning, but the source also covers what I'd call information warfare. Hiding people, tipping people off, messing with data. This feels more like the back end of the operation.
It is, but the penalties are just as severe. Let's start with harboring, which is 18 U.S.C. section 10071. This is basically concealing someone to prevent their arrest by IC.
Like letting someone hide in your basement.
Exactly, or hiding them in a vehicle, moving them from one safe house to another. The baseline penalty is 1 year. But, and this is a really big but, if the warrant for the person you're hiding is related to a felony, the penalty for harboring them jumps to 5 years.
Then there's the tip-off. I feel like I see this on social media all the time. People posting, hey, ICE is at this location, stay away. Is that actually illegal?
Under 18 U.S.C. section 2232, it certainly can be, the statute covers preventing seizure. This includes giving advance notice of a search or seizure specifically to prevent authorities from securing evidence, or in this case, people.
So tweeting out the location of a raid with the intent to help people escape.
Could be charged as preventing seizure, which carries up to 5 years. The law sees it as actively sabotaging a lawful warrant. It's not just sharing news, it's operational interference.
And what about the digital side? The source mentions digital obstruction. This part really blew my mind because of the sentencing.
This is 18 U.S.C. section 1519, and this is a heavy hitter. It covers destroying or altering records to obstruct a federal matter. And in the context of a protest or an arrest, this usually means one thing: wiping your phone.
Wiping a phone, like doing a factory reset.
If you delete data, wipe a phone, or destroy video evidence to keep it from federal investigators, that is a felony punishable by up to 20 years.
20 years? For deleting files?
Yes. Think about that math for a second. You might have committed a simple assault, a 1-year misdemeanor, but because you panicked and wiped your phone to hide the text messages about it, you are now facing a 20-year felony for destruction of evidence.
The cover-up is so much worse than the crime.
by a magnitude of 20. And the government takes destruction of evidence incredibly seriously. It's often easier to prove than the underlying crime, too. They don't have to prove what was on the phone, just that you destroyed it to obstruct their investigation.
That is terrifying. It's a digital trapdoor. And briefly, the source mentioned witness tampering, too.
Yes, Section 1512, intimidation. If you threaten someone to stop them from talking to law enforcement, maybe someone who filmed the incident or just a bystander, that carries 20 to 70 years depending on the details. It's designed to protect the integrity of the whole justice system.
It really seems like the law has every single angle covered. Physical blocking, planning, hiding people, deleting data. It's a net.
It's a very comprehensive legal framework, and it's designed to be watertight to protect the function of federal officers.
We're coming to the end here, and I want to talk about consequences. We've mentioned the prison time, which is terrifying enough, but the source says there's a financial reality, too.
Yes, 18 U.S.C. Section 3571. We're not talking about a speeding ticket here. Felonies can carry fines up to $250,000 for an individual. Even a class of misdemeanor can hit $100,000.
That is life-altering debt. That's a mortgage with no house.
And that's just the immediate cost. The source has a practical note about the long-term impact. A federal conviction means supervised release probation. It means restitution payments.
And your rights. What do you lose as a citizen?
You lose your firearms rights permanently. It can impact your ability to travel internationally. Good luck getting a visa with a federal assault charge on your record. And of course, employment. A federal felony for assaulting an officer is a massive red flag on any background check forever.
It's not just the time you serve. It's the ripple effect to the rest of your life. It just follows you.
It creates a permanent ceiling on your future.
Now, sometimes when we discuss this stuff, listeners might think, well, these are old laws. Do they actually use them? Is this just scare tactics? But the source lists some specific DOJ press releases.
These are real cases. The source points to an indictment in San Jose for an assault on ICE deportation officers at a facility charged under Section 111. There's another case of a Mexican national charged with destruction of property and assault. And that St. Paul case about civil disorder we mentioned earlier.
So these aren't just hypotheticals. Prosecutors are actively using Section 111 and Section 231 in these contexts.
They are. The machinery is active. If you provide the conduct, they will provide the charge.
So if we boil this entire thing down, what's the final takeaway from this deep dive? What's the one thing the source really wants people to understand?
I think the biggest mistake protesters make is assuming that protest protections cover physical interference. They do not. The source is very, very clear on this. Speech is protected. But the moment you use force, obstruction, or intimidation against federal duties, you have left the protection of the First Amendment and entered the jurisdiction of the Federal Criminal Code.
It's a hard boundary. You can say what you want, but you cannot physically stop the government from doing its job.
That is the core message. The law distinguishes very sharply between your voice and your body.
It's a really sobering reality check. We tend to think of protests as these fluid, dynamic events where everything just blurs together.
Right.
But the law sees them as a series of very specific actions, each with a specific statute attached to it.
And those statutes have teeth. Big ones.
I want to leave everyone with a final thought to just mull over. We live in an age of digital activism and physical protest. We join group chats, we share locations, we stand in crowds. But I want you to think about the nuance we discussed today.
The speed of it all.
Exactly. How a single step forward, a specific gesture like grabbing a door handle, or even just one message sent in a group chat saying, let's go block this van. How those tiny split-second decisions can instantaneously shift your status from a political participant to a federal felon. The line isn't as blurry as it looks on the street.
In the courtroom, it's razor sharp, and understanding that line is really the only way to navigate it safely.
That's it for this deep dive. Stay curious, stay informed, and we'll catch you on the next one.